We are live and recording.
Thank you very much. Can you all hear me? I didn't, should have asked before we did that, but can you hear me?
I can, Your Honor.
I can hear you, Your Honor.
Very good. And we are recording and I guess live streaming it at the same time. So welcome to the single justice session of the appeals court. We will be hearing a single matter at this hearing. It is a motion for reconsideration in number 2023J247, TJR Services, Inc. versus Hutchinson and another. The way this is going to work is it's a 30-minute hearing, although it's not clear to me that either of you will need all that time, although you might, so that's why I scheduled it like that. We will hear from Attorney Vowder on behalf of the Hutchinsons first. You will have 10 minutes initially and 5 minutes of rebuttal. And you, Attorney Trainee, will have 15 minutes to argue after the 10 minutes of the movement here. Let me begin by saying something that may not be clear to one or both of you. As single justice, I lack the statutory authority to render any decision that finally decides the case. So I can't order dismissal of the case, even if I wanted to, and I express no opinion on that. But I just give you that heads up, so maybe you won't need to spend that much time on trying to get me to dismiss the case, or trying to get me to not dismiss the case. I think we are ready. A clock will appear in the box that is now black that has the appeals court, I don't really know what it is, symbol in the corner there. And maybe it's the Great Seal of the appeals court, but I don't know if we have one of those. So a clock will appear and it will count down to 0. It doesn't change color anytime during it, but it's right in your face because it's Zoom, so you'll see it. So we will hear first from you, Attorney Vowder.
Thank you, Your Honor. And obviously, I certainly would be responsive to any questions you have or direction as to where you wish this to go. But I would start with saying that I think that a good place to start is that the first summary judgment case did go to final judgment and was not appealed from. And that the
I'm not sure that's a good place to start. I am, as you read in my initial order, I am well aware of the 2017 order of the Housing Court, and I think I understand what it was. It was also without prejudice. I don't have any view about its res judicata effect or not. That's an issue on appeal, I gather, in the appeal from the land court case. So let me ask you a couple questions about the judge's order. Do you understand the order for use and occupancy and access to be a condition of the stay?
That's the term he used in his order.
Okay, so I asked that because at the very bottom it doesn't say that, but in the text, of course, it does say that.
Yes.
So let me ask you this. If I thought he lacked authority to issue use and occupancy, do I do something with the stay order? Because it's really one order. You have gotten a stay conditioned on these things. And if I remove the conditions, what am I supposed to do with the stay?
So with respect to the stay, I think that at a minimum, the stay should stay in place. The request was that the stay on all proceedings.
Yes, but the judge did not allow that motion, except conditioned on payment of use and occupancy. And there's one other I don't remember what the
Access.
no access, but there's one. I thought there was another thing, but yes. All right. So the judge didn't just allow it. The judge allowed it conditioned on.
Well, so I don't think that this court's decision that the condition need not be complete gets rid of the underlying motion for stay on the proceeding, and that would still govern the case. I don't know that
I agree with you that the underlying motion is not affected by it. I'm trying to figure out a single order that creates a condition. Let me ask you, I have to figure that out, I think. I don't know. I mean, I'll ask Attorney Trainee as well, but I think I have to figure that out. Let me ask you, and you have some time and you have some rebuttal time too, so I will hear, whatever you have to say about this. Let me ask you this. If I were to agree with you, what I take to be your position, that under Davis, what is permitted pending a decision of the housing court is use and occupancy paid by a tenant at sufferance, as to whom that description is not in dispute, to the undisputed owner of the property. Let's say I agreed with that. I take it that's your reading of Davis. This is different because the whole question here is who owns the property. And so to make one of them pay the other one.
So I guess I would say that my clients are not tenants at sufferance at this time. And the Davis case is specifically about landlord situations, not post-foreclosure circumstances.
Okay, so I'm going to hear, although we know that in post-foreclosure circumstances under King, we know that after a judgment finding someone to be a tenant at sufferance, then use and occupancy can be ordered pending appeal. But that's not this case.
That's not this case at this time.
So what I'm going to hear from Attorney Trainee, certainly, is yes, you are tenants at sufferance because the land court judgment that is final in the sense of a judgment entering, not final in the sense of still being on appeal, still has res judicata or some preclusive effect. And so unless until that's overturned, the lower court can treat you as a tenant at sufferance.
And what I would suggest is that I'm not sure how you can come to the conclusion that a judgment that has been entered that has not reached its conclusion, either that the time for appellate review has expired and or the appellate review itself has been exhausted. I don't know how you get to the point where you can say that that is a final decision upon which relief one way or the other can be granted.
Okay, so let me ask you this. Let's say I agree with you about that. So now let's say I agree with you. Davis doesn't cover this. We don't know who's a tenant at sufferance here, or if there is one. We don't know who owns the property, or at least the housing court, let's put it that way, doesn't know. We have a land court that thinks it knows. We have an appeal, but we don't have a housing court judgment on that. Let me ask you this. Why, nonetheless, can't a court say, yes, I understand that, but you've asked for a delay. You've asked for a stay. And that's fine. I'll give you the stay. But in the interim, I'm going to treat you as though you've lost the case. I know you haven't. And one quick way to figure this out, quick-ish, would be let's have a trial right away and figure out whether I give res judicata effect, or I don't know if the jury does. I really don't know anything about how that would work, but let's do a summary process action, figure out who the owner is and move forward. And I'm willing to do that. Let's say the judge says implicitly, but you've asked me to stay the whole thing, and I will. I don't want to create havoc in different courts and different rulings. I'm willing to, but that's not my first choice. And you've asked me to stay it. So, okay, I'll stay it. But I'm going to treat you as though you've already lost. We'll pay it into escrow. Some of it isn't, I know. We'll talk about that too. But if you want this delay, you can have it, but I'm not going to disadvantage the other side. I'd like to, let's start with put in escrow. I'd like to have you put in escrow these payments. Look, if you win here, you'll get them back. And if not, you have to pay them. And it's not pending appeal, because it doesn't say pending appeal.
Right.
It's a pending final judgment in my case.
But I don't see how use and occupancy apply. So what I would argue, Your Honor, is that the eviction case 239 is a statutory remedy, or a statutory and a legal remedy.
Mhm.
And attempting to apply use and occupancy is an equitable remedy. And I don't believe
Is it to stay equitable, or at least within the discretion of the judge, right?
I guess it's still within the context of a case that's based on law and not on equity. I still think that there's got to be a distinction as the nature of the case. And until the legal piece is not sufficient, or the legal piece is not, and then maybe you can reach out and get to an equitable position. I don't believe that you can fashion an equitable remedy now on a case that is a legal one and has a legal remedy.
Let me ask you this. If there were no stay in place, and this went to judgment before the land court appeal was heard, what would happen on the ground and what would happen as a matter of law?
Well, so if this case went to judgment without waiting for the land court case, I would suggest that at that point, depending on what the judgment is, obviously if it goes in my favor, it's fine. But if it goes in favor
let's say it goes in favor of
TJR,
maybe on res judicata grounds, I have no idea, but or on the merits, whatever.
If it goes in favor of the TJR, at that point, I believe the case is clear that once a judgment enters, that a decision can be made by a judge with respect to use and rent and use and occupancy. And rent doesn't apply in this case, but perhaps use and occupancy may apply. And it could be, it doesn't have to, but it could be that a judge could hear arguments about use and occupancy.
And also an appeal bond.
Well, that's only if I appeal it.
Well, use and occupancy is only if you appeal, right? Otherwise you have to.
No, I don't believe.
You?
I need to be careful, but my understanding under, was it Save More?
Well, you'll know this better than I am sure, but go ahead. Yeah.
But that at the conclusion of a case in which judgment is found against a post foreclosure eviction party, that use and occupancy can be awarded.
And what's the penalty for not paying it?
Well, but this
It's
is
still
after
eviction, right?
But this is after the judgment, Your Honor, not during
No, I understand that. I'm trying to figure it out. Do you believe that with the land court action pending, someone could execute on the housing court judgment?
So it's possible. Of course, it is possible, Your Honor. I don't think it ought to happen.
Would that moot the appeal in the land court case or not?
I don't think it does. I don't think it does. I guess I would have to think about that, but my initial response is no, that the land court case still has viability as to whether it needs to be
Hutchinson's, if TJR were to win in the housing court, the Hutchinsons could be physically evicted, but still maintaining their position that they are the owners of the property and that it hasn't properly been foreclosed on. They could then win in the land court and move back in.
I think that's right. I mean, if I think my way through, I mean, no one's asked me to think this particular issue through. So
I have to say, the two of you have given me a far more interesting single justice session than I'm sure I'm entitled to, because I've never thought about any of this before, because I've never seen anything like it. So.
And I don't understand how the first summary process case doesn't impact this.
And if I had been the land court judge, you could have made that argument to me. But I'm not deciding that, of course. That's on appeal.
Right.
All right.
The land court, the original summary process is not. I agree, the land court is.
I agree with that. All right. Your time has expired. We've gone over a little, so if you need a little more attorney training, I'll give it to you. I will hear now from you.
Thank you, Your Honor. Your Honor, it's our position essentially that the Hutchinsons asked for a stay of the housing court case, which in theory, from a practical standpoint, we weren't opposing because in the grand scheme of things, it did make sense.
So can you tell me, do I have someplace in the record, or is it in transcript that I don't have, that you agreed to the stay?
Well, here's what we did. When Attorney Bowder filed the request for the stay, we said that we would not oppose the stay if there were a use and occupancy payment pending the stay. We wouldn't get into the issue of whether or not there should be a stay if there were a use and occupancy payment made.
Okay, well, I don't know that that's agreeing to the stay at all.
Well, again, it may not be, except that the judge, after argument, decided that he would consider the stay conditioned upon there being a payment of use and occupancy or some amount.
You didn't file a cross motion, but in your responsive filing, you said
our
as
opposition,
long as there's use and occupancy.
right? As long as there's a payment made.
Okay, so let me ask you this. If I agreed with Attorney Vodder that without some determination more than what the judge put in about the land court case, but actually either saying I am giving it preclusive effect, or I don't know if they can do that because I don't know what procedures they're supposed to follow before deciding who owns property. But if I were to agree that without that, the judge can't treat the Hutchinsons as tenants at sufferance, and that you can't get use and occupancy unless they are. And the judge seemed to understand they had to be. The judge says they are holdover tenants at sufferance, no citation, and then says there's no decision from my court, but the land court said X. And then he goes on to say, so I'm going to stay with these payments. And he mentions Davis as well. All right. So if I say that condition can't, at least without some additional process or something, can't be imposed, does the stay survive or it doesn't survive? Or it's not up to me, it's not on appeal?
Well, I think that by the mere fact that we're the record title holder, we have the right to commence the summary process action.
I didn't ask if you had standing to commence the summary.
No, I understand that. But so what I'm saying is that if the judge then decides that equity is such that given the totality of the circumstances, he thinks that it's appropriate to stay the proceedings while the appeal makes its way through the system, I think the judge has the ability under his power to issue an order that says that as a condition of the stay, this is what my condition is going to be. Whether he calls it use and occupancy or a payment for the stay, I mean, I don't know whether he has.
I don't know what a payment for the stay is. We don't sell stays.
Right. So that's what I'm saying. So what I think he's saying is that in the world of the housing court, a stay would normally be accompanied by some type of interim payment. And
wait. Have you? I've never. I don't see everything, of course, but I've never seen someone get a stay and make an interim payment. Do you have case law that that's permissible?
In the housing court specifically, or
yeah, anywhere. But let's start with the housing.
Well, if you look at it, if you look at cases where there is an appeal filed in a housing court decision
after judgment,
after judgment,
okay, but you said if you get a stay, it wouldn't be after judgment. It's a stay of ongoing proceedings. So far as I know, there's only one published opinion about this, appellate opinion, and that's Davis. And that's a much different circumstance, it seems to me. The person being ordered to pay wasn't claiming they're the owner. They were just saying, I have this crummy apartment and I shouldn't have to pay the full rent because and I'm withholding it because it's not inhabitable.
Well, so again, though, I go back to the ability to rely on the land court judgment
I
as
know
the
you,
final judgment.
and I don't know, see, this is tricky, and I'm not going to answer this question because I don't know the answer. Because I don't know enough about housing court procedure. Ordinarily, the way a housing court figures out who owns a piece of property when it's disputed is through finishing their summary process action. Right? But now we have this like interim order that basically says, we haven't decided, but the land court has. It doesn't say, I give this res judicata effect, and therefore the housing court finds. I don't know if they're, I just don't know enough about summary process actions and what rights the parties have to know if he can even do that. But he didn't do it in any event, even if he could, he didn't do it. He just said, sort of in fairness, he did describe them as holdover tenants and tenants at sufferance. But can he do that without actually concluding that they are?
I think if he relies on the judgment in the land court as being preclusive.
Let me ask you this. I don't know anything much about jury trial demands in these cases. Is your position in the case below simply that it's res judicata? Here's the case. We are absolutely the post foreclosure owners of this property. We'd like you to evict this holdover tenant or holdover prior owner, whatever you want to call the Hutchinsons. And thanks very much. We don't need to do anything else. You can decide this on the papers.
That would be what our position would be. Is that if there were no stay and the housing court case continued, that what we would do is file essentially a motion for summary judgment using the land court decision as preclusive, and that it would that at that point they would end up being a judgment in our favor that we're entitled to possession.
Assuming there can't be this condition, do you want to stay?
Not particularly. I mean, again, I think we were doing it.
Well, I don't know anything about it. You have done a little bit of forum, I'm not going to say shopping, I'll say selection here. And you have chosen to go to the land court, and there may be very good reasons for that. It's certainly a more thorough process than you can get given the press of business in the housing court. On the other hand, you didn't go into the court that had previously ruled that your predecessor in interest was not the proper entity to foreclose. So whatever, you chose the land court. You come into the housing court, but do you actually want them to decide before the land court appeal is done? What would happen? Let's say they decided, what would you do?
Well, I think what would probably happen was what happens in most housing court cases is landlord gets possession, tenant appeals. There's a stay, if you will, entered pending the appeal, so it doesn't allow the landlord to evict. There's either a bond posted or a use and occupancy payment made during the pendency of the appeal. And then when the appeal's decided, then whatever happens on the appeal is what gets carried out in the housing court.
Let's say Attorney Vouter doesn't appeal. He thinks to himself, I'm about to get a higher court to say, I own the property. I'll just go with that. I don't, right? We can come in with a 60B, or I don't know how this would play out. But let's say he doesn't appeal. Now you've got a judgment from the housing court. Do you move to evict him? What do you execute on the judgment?
I would move to evict him on the housing court judgment. And then at that point, I guess.
What would happen to the land court appeal?
I don't think anything would happen to it. I think the land court appeal would continue on its way, subject to the housing court judgment being overturned if the appeals court decides against what the land court did.
So but no one's accepted a highly discounted price, although you may have paid a highly discounted price as well, it appears. No one's buying this property pending that appeal, right?
No,
Nothing.
it's not even something that the clients have considered at this point, and whether
Okay, but you're not fixing it up pending
we-
appeal, right? You're not going to throw money into it not knowing, right?
Well, I mean, to be honest, Your Honor, the reason why no one's doing anything is because there was resistance in the sense of even getting in to do the inspection.
I understand that, I understand that their position is,
Sure,
we're told in 2017 it's our house still.
right, and that's okay. But even if they're right and it's their house, if you look at it, I look at it more from an equitable perspective, in the sense that even if they win, what they win is a house with a mortgage that doesn't go away.
Yeah, but you don't get any money from them.
Well, I do believe
if they win, you don't get any money from them. Someone.
Well, that's I don't necessarily agree with that, Your Honor, because I think that there is some precedent that says that if there's a foreclosure and it turns out that the foreclosure isn't valid, that it may be that what the person who bought it, the foreclosure, gets is an assignment of the mortgage, because that's all that the foreclosing mortgagee could tender.
I mean, I mean, we're going well beyond.
I know we are, and we are, and I don't mean to. All I'm saying.
No, you have, maybe you have to. I find this very complicated, and these are some of the reasons. Let me ask you this: do you agree that you can't execute on the land court judgment?
Execute as in?
I don't have any idea how one executes on a declaratory judgment, but do you agree that you can't execute on it?
I can't execute on it I can't execute on it and move them out on a declaratory, on the judgment in the land court, without going and taking that judgment to the housing court and moving to take them out.
If you are ordered, if you win in the housing court, let's say the stay is lifted and this goes to judgment. I don't know how fast that is, but whatever. And let's say it's before the land court appeal is decided. Would evicting them be executing on the land court judgment?
No, evicting him would be executing on the housing court judgment. That was, in fairness, I suppose, probably based on the land court judgment, but we couldn't evict him without the housing court judgment. So that's what we would do. We would move forward and do that.
And then if the appeals court reversed the land court judgment, would you have to pay to put them back?
No, they already have to pay to put them back. I suppose that would be ultimately a decision for a judge somewhere, but I imagine they would get the ownership rights back, and then they would have to get possession back
From you.
Right. Because then I would be in possession.
I assume
Same way that they are. They're in possession.
No, because TJR doesn't need a place to live, and the Hutchinsons do. I assume you wouldn't. What are you going to do? Like,
well, whether we would put somebody.
No, you can't. Like, it's your house. You can't. I mean, you're right, but.
And that's why I go back to the argument being from an equitable perspective is that what we asked the housing court judge, and essentially what this is all about, is it makes sense from a legal standpoint for things to stay the way that they are while this appeal is pending. I don't think anyone would argue that.
Okay, but the way that they are, you weren't getting any use or occupancy.
That what I was going to say was the way that they are, because until the land court judgment came out, we didn't have any
rights
other than record title rights, and we hadn't pursued that in the housing court.
No, I noticed that you didn't pay any insurance on it. You bought it in 2017 and started paying for the insurance in 2023.
There was a question at one point whether who has an insurable interest too. We did pay the real estate taxes though, all the way along.
When did you pay those?
Our predecessor in title paid the real estate taxes when they bought. This client paid the real estate taxes when they bought, and then they've since paid the real estate taxes that were assessed against the property. So
That
they've
is
been
to say,
paying.
now was there a tax? What was there? It wasn't taken. There's just a bill or what?
Yeah, it was not a taking that went to a lien, like a lien. It was the sort of the notice you get before that,
Okay.
it didn't get as far as a
And
lien.
that was for back taxes back to whenever the last tax payment was paid.
That's
by the
correct.
Hutchinsons. When did you
Oh,
pay
no.
that?
No, after the predecessor, there's an in-between title holder between the
Yeah, I
foreclosure.
know.
And so they paid some when they purchased, TJR paid some at their purchase, and then they have since paid. So they have paid the taxes.
Well, they have now. I mean, it doesn't really matter to me. I'm interested in when they did they also pay a lump sum in January 2023? That is, did they wait till they thought their title was clear to pay all the taxes back?
No, they had paid them. They had paid them prior to that. No.
Well, I gave Attorney Vaughter, who does have a few minutes. Is there more you want to tell me? This is just such I don't know. It's like a morass. Oh, let me ask you. So, do you believe that if I don't think the condition is okay, I have to vacate the whole order, including the stay?
You mean by the condition as in the condition?
If I don't think that the use and occupancy order, or the access order is adequately supported, do I get rid of the whole order because it's a condition, or do I just get rid of the condition?
No, I think in fairness, that goes back to the housing court judge to decide what he wants to do if he's not permitted to do what he thought he could do, which was to enter the stay conditioned upon the payment. Because I think that was what was in his mind, when he entered the order.
You see, it says condition. Neither of your filings happen to mention that it was a condition.
Well, we had asked that.
I know, but as I was digging through all of this, I had whatever. I must have seen it before, but I didn't like, oh wait, so all right. Your time has expired. Do you have anything else you want to add?
Just, Your Honor, that again, all we think is that from an equitable perspective, the fact that since the Hutchinsons are living there, that this notion that they would pay to stay there by paying things that benefit either party, if whoever ends up owning.
No, that seems wrong to me. How can it be? All right, let's say both of you claim to be the record title owner. Now, the truth is neither of you was paying insurance for years.
Well, I don't know if the Hutchinsons were up until
my sense. Well, until 2023, I don't know either. I think I do know, actually. I think they were not for some period of time. But the owner gets to decide whether to buy insurance on their property. I understand they may have an obligation under a mortgage or something, and then they may be in default, but they get to decide whether to buy insurance or not. I don't think a court can just order an owner like, your house could burn down, but buy this. Say, look, if you wind up owning the house, then you'll thank me. I just don't see that. I do see if they are a tenant at sufferance, saying here's some use and occupancy, but I mean, I understand it, like at first blush, that seems like common sense, that it benefits either one. Although then the question might be, well, maybe they'd choose a cheaper insurance company. How come you don't let them pay and you pay them? Like, why are they paying all of it? And the reason they're paying all of it, presumably, instead of half, even if it's going to benefit either of you, is because the judge said they were tenants at sufferance. But I've interrupted you in a way. So
no, I think the point I was making was that if to my mind, if someone's claiming that they are the owners of the property, And if they own it with a mortgage obligation, and the mortgage obligation obligates them to insure the property, to pay taxes on the property. And so at the very least, I think if that's the position,
yeah, go ahead.
they want to, if that's the position that they want to say that they're in, is we're the owners of the property. That's our claim. And that if we own it and the foreclosure was bad, there's a mortgage on the property, that those are obligations that they haven't paid.
But I've never heard of a court, there's remedies in the mortgage. I've never heard of a court literally enjoining someone to pay your taxes, pay your insurance, or you'll be in default.
No, I'm not. But here we've got a situation where there's been a determination that somebody else is the owner of the property.
Well, I agree. That's your strongest.
No, and all I'm saying is that if you look at it from an objective point of view, the things that you would pay as an owner of a property are taxes and insurance.
I understand that, although you've been awarded more than that. You've been awarded use and occupants. That's just a first, like an obvious first step.
Mm-hmm.
If you are entitled to use and occupancy, if you are, then that's all fine. If you're not, then it's not all fine. It seems.
No. And I understand that the housing court judge's position that it goes into escrow, and that it will be released at some point in the future. So
sure. We don't usually, right? I mean, again, maybe as a condition of the stay, maybe because of the prior judgment, but in an ordinary case, we would never say that, right?
No, actually, in a lot of housing court cases that are on appeal, judges
on appeal after there's a judgment. But ordinarily, two people come in, one says I'm the owner, the other says no, I'm the owner, and they're duking it out in the housing court. We don't make anyone, while that's pending, pay anything into anything.
Well, I think it depends on the situation. I think that there are cases where people are paying while the case is going on. It's just a question of how it's being handled, whether it's rent or what the specifics of that situation are.
All right, you have 5 minutes left, Attorney Vouter.
Thank you. All right, I guess I just want to pick up on this, what use and occupancy is, and I think there really is a use and occupancy, like rent, I guess, is for value in being in a property. It's not for paying taxes, which have constitutional implications, which have or ordering to pay mortgages. What the person who receives the use and occupancy does or doesn't do with it, whether they mow the lawn or whatever it is that they do, however they apply it, that's up to them to apply.
No, I agree. There are some property rights issues lurking right underneath the surface here. Let me ask you this. Attorney Trainee basically told me she did not really agree to the stay. She agreed to a stay with conditions. Do you agree with that?
Well, my sense is that what she filed with the court was basically her opposition to the stay. Okay. And then she said, she would, if there was, then at some point in her opposition, she's not as hard boiled as it could be, but it wasn't upon order of the court. It was upon agreement of my client to pay use and occupancy. That was what she said. So
does the judge issue the stay? I'm asking the same question I asked you before. I don't assume any of us has a clearer answer to it. If the conditions aren't okay, what do I do?
So I believe that a stay has its own independent significance from use and occupancy.
I agree with that.
Whether a stay, I guess I am more on the fence or less certain as to what I think a stay is in relationship to a legal case versus an equitable case. I guess that's not as clear.
We do know from Davis, we do know that the housing court has equitable powers.
At what point, I guess I would say, do they have the equitable powers?
Do you think that the stay is legally required?
Well, I think legally required, he should have dismissed the case. legally.
I am aware
All
you
right,
think
so legally, that's what he
I
should
will
have done.
say also, I don't need to reach the question of whether you asked me in a timely fashion
Yeah.
to reverse that, because I don't have the authority to do it, but it looked a little late to me.
Well, it seems to me that I think the court has the power to stay the action. I think that it makes sense, as Rosary Training says, it makes sense to stay the action pending the outcome of the appeal in the land court. It makes sense. Where that fits into changing the legal parameter of a case in law to a case in which equitable decisions can be made, I think is still statutorily, and because it's a law case, you don't get to go there. They will have their time and their chance when a judgment enters. They will have their time and
They
chance.
may wind up having a merits decision out of this court pretty soon,
They may.
right? The judge may, whatever I do with the stay, the judge may be like, I only issued a stay because I thought I could do this. I'm not issuing the stay, and may lift it.
It could revisit it. He certainly could revisit. I mean, so I just think that it is important to distinguish between the law versus equity, and that we are not at a place where equity ought to control this situation for purposes of establishing a payment of use and occupancy in order to pay real estate taxes and insurance.
Well, it's going to be more than that, right? Because if I uphold the use and occupancy, there'll be further hearings and real use and occupancy will be charged, right? That was the next step here.
Right.
So it won't, like, the questions about, maybe I sort of made this clear when I was talking to Attorney Trainee, the questions about who does it benefit, those are going to vanish. There's kind of a sideshow anyway, because these are use and occupancy payments. They're not, why don't you guys split the taxes because we don't know who's going to win. I'm treating the TJR as the winner pending this stay and pending final determination. So, all right. You're both very fine lawyers. This has been really interesting for me, at least. I don't know. You may have had something better to do this afternoon, but there we are. Do you have anything to add to that, Attorney Vouter? Your time has expired, but
my time's expired. I probably always have something to add. I don't think I'm alone. That's the profession I chose, but I am prepared to rest on what I've said so far.
All right. This has been helpful to me in clarifying my thinking about at least what's going on here. So thank you both very much. I will try to get something out on this motion soon, and the case is submitted.
Thank you, Your Honor.
Thank you both.